Hello, and welcome to the motions page. Before we continue, there is a disclaimer. The information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Now I will be discussing what a motion is and how they can be used and what kinds of motions there might be. The general overview is that motions are written documents that ask the court to make orders. Motions can come before, during, or after the trial, and any party may file a motion. Motions must state exactly what grounds are had for the request that is being made. The opposing party may contest the motion by filing an opposition to the motion. There is a filing fee and it varies from county to county, and every motion must be filed within a certain time, making it important to be aware of the filing date. Certain motions are intended for pretrial and other motions can be filed during the trial, and others are intended for post-trial. It is important to keep track of what motions are available to you because the court will not notify you. Motions must be filed with required papers such as a notice of motion, the motion itself, a memorandum of points and authority in support of the motion or demurrer, declaration, and a proof of service by person or mail. Now we will go over the types of motions there are. Motion for directed verdict, which is a motion to direct a verdict based on inadequacy of evidence presented to prove the case or support a defense. Motion for fees and costs is a motion to fix fees by the prevailing party. Motion to tax costs is a motion to avoid the request for fees and costs. Motion for judgment on pleading is a challenge to sufficiency of a pleading after a response has been filed. Motion for a new trial is a request for a new trial based on a problem with consideration of evidence by the fact finder. Motion for protective order is a motion to avoid responding to discovery. Motion for reconsideration is a motion made for the second time but on additional facts. Motion for rehearing is a motion made for the second time requesting the court to correct a mistake made initially. Motion for limine is a motion to eliminate specific evidence at trial. Motion to compel answers is a motion for an order to compel answers after respondent fails to respond. More types of motions. Motion to compel for further answers is a motion for order requiring respondent to provide additional answers to discovery. Motion to dismiss is a motion to terminate action. Motion to quash service of summons is a motion to render the summons ineffective. Motion to renew is a motion made for the second time on new facts. Motion to strike is a motion to exclude improper or irrelevant matter from a pleading. Motion to transfer action. Motion to transfer action is for a convenience of parties and witnesses. Motion to vacate judgment. Request to strike a judgment based on improper application of the law and to replace it with another. Ex parte motion. Action taken without the presence of another party. Now I will briefly explain the forms needed. The required papers are 1. Notice of motion is a proper notice served to all sides with a brief description of the notice and dates for which the hearing and the time to respond is given, and is given 16 days before the hearing on the motion by service in person or 21 days by mail. 2nd, a memorandum of points and authorities is a document that refers to statutes and court cases that explain how the authorities support the position of the party who writes the order to support motion. 3rd, a declaration is written statement that is to be the truth under penalty of perjury by a person with direct knowledge about the issues in a case. And 4th is the proof of service by mail, is a court paper that shows the paper was served to the witness or the party in a lawsuit. Thank you for visiting this page, and I hope this information has helped.